item on our agenda. This is Senate Bill 2523 relating to medical marijuana, a hot topic, a trending topic here in the state of Hawaii. This measure allows production centers to be greenhouses, shade houses, and open-air growing operations, provided that they are not visible from any thoroughfare. Department of the Attorney General. Thank you.
Chair, as a member of the committee, Tara Mola, on behalf of the Department of the Attorney General. The bill would benefit from a few improvements. First of all, defining shade house, greenhouse, and fenced-in open-air growing operations. And the phrase "shall not be visible" should be clarified. Currently, it's not clear whether it refers to the structure or its interior, the contents therein. Thank you.
Okay, thank you, Tara. Department of Health. Good morning, Mr. Ridley.
Good morning. Department of Family and Citizen Testimony providing comments.
Okay, you want to share those comments?
Good morning again. Keith Ridley on behalf of the department. Essentially, those comments have to do with, as the Attorney General just said, providing definitions. As the chair may be aware, the current interim administrative rules excluded greenhouses from the definition of an enclosed indoor facility. And this bill seeks to allow greenhouses and shade houses, et cetera, to be provided. And the department doesn't have a problem with that so long as those terms are clearly identified and defined, so that can give us some additional guidance in doing the rules.
Okay, thank you. Department of Public Safety.
Department of Public Safety stands in opposition and submitted testimony.
Okay, you want to share your opposition? Because the chair doesn't quite understand it.
Good morning, Chair, members of the committee. Sean Sua, Deputy Director, Department of Public Safety for Law Enforcement for Director Nolan and Spinda. So the department's position is that we understand the challenges of grow operations, whatever type of agricultural product, but we would like to see the present protocols as articulated for the medical marijuana program be implemented first. As you know, the Department of Public Safety's Narcotic Enforcement Division will be responsible for ensuring the security of the sites for the registration process and so on and so forth. So we are concerned about having open-air growing operations as to the security, because basically if we have not a hardened facility, but a building that contains the grow operation, we consider that a lot more secure than if you were to just have a greenhouse with surveillance cameras. That's just our concern.
Okay, thank you. The committee can share with you some of the experiences of seeing greenhouses that are probably more secure than anything you've ever seen, but we appreciate the comments. Hawaii Dispensary Alliance. Good morning.
Good morning. Aloha, Chair, members. My name is Christopher Garth. I'm the Executive Director of the Hawaii Dispensary Alliance. We stand in support of this measure. Of course, we have a few reservations, and not to sound contrary to earlier testimony that we provided in the House, but some of the concerns about contaminants do not apply in our testimony to open-air grow facilities. They're specifically for the closed facilities that we discussed in earlier legislation. So I'm available for comment or questions.
All right.
Thank you.
Policy drug forum or drug policy forum.
We stand in support of that on our
Okay, thank you. Community Alliance on Prisons. Kat Brady. I don't see Kat in the audience. Kari Hardin in support. Denham Creighton, support. Dennis Gage, support. Georgina McKinley, support. Francine Pearson, support. Kalavai Gu, Jeffrey Laser, Leilani Satori, Louisa Wooten, Terry Marks, Katrina Kalina, Robert Petrici, Mary Overbay, Kamaili Makikau, all these folks in support. Tina Waldenberg, Patricia Blair, Eloise Engben, Lee Einstein. Anybody else here wishing to offer comment on this measure? Yes, ma'am. Do we have your written testimony?
No.
Okay, you need to leave it with us, please.
Pardon?
You need to leave written testimony with us so we can have it for the record?
That I can write after?
Yes, but ASAP after.
Okay, today?
Yes,
Okay,
thank you.
thank you. Thank you very much. My name's Ellen Watson, and I'm just a member of the community. Although I was faculty for JABSOM and am very familiar with laboratories and accreditation and testing. Just as a matter of background, I think this is a really wise,
Are you testifying in support?
in support
Thank you.
with amendments.
Okay.
Or suggestions for amendments. I think it's a common sense bill. I think that open air growing in greenhouses certainly can be secured. I agree with you on that, beyond just security cameras. My problem is this. I think that it's a bait and switch as we begin to change these things. I think it's a disservice to the 59 applicants that were there because they made their bid based on having to grow in a tomb. So this dramatically changes their business plan and their financial plan. I think it's a disadvantage to other people that would have been applicants if they could have grown in greenhouses or an open air growing or some kind of a scenario that didn't require somewhere between, 10 and $20 million to erect their tomb and generate all the in-growing engineering controls and those kinds of things. So in that regard, I think the big question over all of these things and things that have been heard in the House is that you need to open up the application period. You need to back it off a little bit, at least till the end of session. You guys need to get it right. And you tried last year, but the bills and the Department of Health rules have some conflicts in there. And I really want you to iron those things out, and I think you really want to do that. But I just think you have to open it up, back it off by 2 months, and do it really well, and I'm sure you can do that. And so that's my concern.
Thank you very much. Anybody else wishing to offer comment on this measure? Members, any questions? Senator Sparrow?
Thank you.
Because I know you must have some.
DOH. I mean, I could understand Ellen's, the previous testifier's testimony, but to reopen it, I think it's just not anybody's preference at this time. But the biggest issue we had was defining a greenhouse. And I don't think we're ready for open air growing as well. But I think traditionally many of us thought of a greenhouse as this shaded structure in the back of someone's yard or farm where you saw plants inside and you could easily break into it and cut it with a cloth-like, tarp-like, whatever the case may be. But today greenhouses can be made of glass, can be very secure, can be unbreakable. You can't see through them. And those are requirements in the current law, correct? A fenced facility, cameras, can't see through it, basically secured for the growing.
Correct.
So, I mean, could one say that greenhouses, if they fit those current requirements in the bill, would be allowed?
And perhaps even going further and clarifying the definition. But yes, I think you're getting toward that area where you're really defining what the greenhouse is. If it's a solid structure that's got a solid walls, a solid roof, it's not just something that could be easily broken into, or where the products would be visible from outside. Those things begin to fit the definition that we had described as an enclosed indoor facility in the rules.
And you don't think if we were to make that clarification, that would conflict or contradict current law, is that correct? To the point where someone might say, hey, you're changing the rules midterm, we're going to sue you, or a lawsuit's going to be filed, or,
It seems, based on the spirit of what you're outlining, it seems as if it would comply with current law. But again, to look at the specific definitions would be helpful.
Right. I mean, I think that's going to be the key to amending this bill if we do move it forward, to how do we define what this is? But yeah, from my perspective, we could do it without conflicting with existing law, and I think that's a key point. Now, would a sliding roof, in your opinion, fit in that, where you would have it secured, but let's say there are sunny days, and there are many sunny days in Hawaii, where a roof could, almost like City Hall, not that we're going to grow in City Hall, but you understand what I'm saying. Do you think that would fit into the current definition? I know that's probably a little more complex answering.
It would be a bit more complex. I think in terms of roofing, as you drive by any of the bigger box kinds of stores like a Walmart or Target or what have you, if you have an elevated view, you see that they have a significant amount of sunroof types of components,
right,
where a lot of natural light is allowed to come through, and yet you can't see through them as well. I think something like that. I think something like that would be an advantage as well, as far as allowing more natural sunlight in.
So at this stage, a moving roof might be questionable or suspect at the time.
Well, I think, again, looking at what that would mean, I think we'd have to look at that more closely, but certainly something that we would look at, sure.
Thank you.
Anybody else? If not, thank you. The next item on our agenda is Senate Bill 3009, relating to medical marijuana, defends the definition of debilitating medical condition to allow for greater physician discretion to prescribe low-potency medical marijuana. Department of the Attorney General. Good morning, Jill. Good morning.
As you can see from our testimony, we oppose this bill. This bill would allow physicians to certify patients to treat any medical condition or illness for which the physician determines that marijuana might provide some relief. But there's no means in the bill for DOH to make a distinction on the registration cards or in the registry, whether it's that kind of a patient or the other kind of patient who can use any type of marijuana with a higher grade of THC. And that would deny law enforcement the means of determining whether a person's in possession of, who is in possession of marijuana is allowed to possess whatever kind they have. If we could get past that, there's still a problem because there's no means for law enforcement to tell what kind of marijuana a person has. You cannot look at the marijuana and know the THC content. So it would put law enforcement in a position where they would have to confiscate all of the marijuana and have it tested. And there's certainly some types of marijuana with some patients that you would not want that to occur. Physicians, getting back to one of my first points, physicians could certify patients for any illness without ensuring that conventional legal treatments are tried first. And they can already do that pursuant to 329. They can certify patients to use marijuana if they determine that the patient has a condition that produces severe pain, nausea, seizures, spasm, PTSD, or other conditions, or treatments for those conditions. But this bill would allow physicians to go further and certify patients who have no pain, no debilitating symptoms, no seizures, or no adverse reactions to any other treatments. So if a patient, and well, this is inconsistent with federal law enforcement priorities, and there is an alternative in our current law, and that is if a patient does have a medical condition that they present with, but it's not on the list of debilitating medical conditions, they can go to the DOH, and likewise the condition and the symptoms are not on the list. They can go to the DOH, follow the DOH's rule process that will determine if that brand new condition is something that is in fact debilitating, and DOH can put it on the list of debilitating medical conditions. Otherwise, this bill
could make it appear that the state is undermining the federal law enforcement priorities by really expanding the group of people who is allowed to possess and use marijuana, and that would be a law enforcement problem both for us on the state level and the federal level. So we respectfully request this committee to hold this bill. Thank you.
Thank you. Department of Health. In opposition. HPD. Good morning.
Good morning. I'm Jason Kawabata, Captain with Honolulu Police, Narcotics Vice Division. We oppose this bill. When this program was set up, it's supposed to be highly regulated, but I see it as an effort to deregulate, and it really opens up for abuse of the system. There is a process in place already in the current law, which basically says, aside from what is already listed as debilitating medical conditions, any other medical condition approved by the Department of Health pursuant to administrative rules in response to a request from a physician or potentially qualifying patient. At least this process affords some level of oversight to discourage abuse of the system. And really, if more people start abusing it, I think you're going to hurt the ones who really need the medical marijuana.
Okay. Thank you, Captain. Hawaii Dispensary Alliance.
Aloha. Christopher Garth again for the Hawaii Dispensary Alliance. Thank you, Chair. We are in support, of course, of this bill, but we do have a few comments. We find that the 5% is going to be a little bit difficult to regulate at the dispensary level. So for that, we ask that perhaps you retract this language or remove it from this bill. But everything else provided specifically in the introductory paragraphs of this bill, the intent, we stand in full support of. So thank you.
Thank you. Unfortunately, our introductory paragraphs never make it into the Hawaii Revised Statutes. That's just only in session laws. It's designed to let people know what we're up to. Drug Policy Forum of Hawaii. Testimony and support. We have a number of individuals. Kalavaya Gu, Katerina Kalina, Carrie Marks, Leilea Satori, Keith Kamita, opposition. Anybody else here wishing? Yes, ma'am, please come forward. Good morning.
Good morning, Chair Baker, Vice Chair Kidani, members of the committee, Deputy Prosecutor Tricia Nakamatsu on behalf of the Honolulu Prosecutors Department. We are strongly opposed to this bill. As some of the prior testifiers indicated, we feel that this would give just way too much and indeed complete discretion to physicians to certify patients for medical marijuana up to 5% THC for essentially anything. And there would be no minimum standards, no symptoms, indications, limits that would guide who or when medical marijuana could be certified for. We are extremely concerned that these amendments would open the process to individuals who would abuse privilege, such as physicians whose sole or primary practice is issuing medical marijuana certifications, regardless of whether there is a true debilitating condition that warrants use of this highly controversial drug. As we noted, the proposed definition would leave no minimum standards, symptoms, or other parameters for certifying use of medical marijuana. And as such, there would be no assurances or safeguards to see to it that there's any consistency in future medical marijuana certifications. Unlike other medications, which have well-established medical indications, symptoms, dosages, limitations, and warnings, which are recognized by the medical industry and self-policed by the various medical associations, medical marijuana has no such parameters within the medical field. That being the case, there would then be no limitations either in the medical field or in the legal field to limit or enforce against physicians who would choose to abuse this privilege. In essence, a physician could issue medical marijuana certifications to every single one of their patients for really minimal reasons, or perhaps theoretically no good reason at all. In short, we do feel this goes much too far in removing any standards, limitations, and consistency for certification of medical marijuana use, and that would open this to open the process to huge opportunities for abuse. We'd also note that people who grow their own marijuana would have no idea what the level of THC is. In addition, prior testifiers indicated law enforcement in the field would have no idea, but this is just another problem that we noted.
Okay, thank you.
Thank you.
Anybody else wishing to offer comment on this measure? Yes, ma'am.
I'm in support of this measure. And I was a little concerned with the levels of THC and being able to verify that, so I think you should just plain open it up to medical marijuana. And I think that in the bill, it talked about that PTSD was added by Act 241, okay? Until then, there was this petitioning process, and it has done nothing in 15 years. Nothing has been petitioned through this DOH process to allow any other medical condition to be in there. So obviously, it just seems common sense and reasonable that it doesn't work. So I think you should just jettison this petition process. And I think that doctors prescribe medications for patients based on conditions. And I think that we have to trust our medical professionals to do that. And so any doctor can prescribe, Vicodin or oxycodone or any other icky narcotics that have lots of side effects for patients that they deem as necessary. And they write in their prescription or in their medical records what supportive information needs to be there. And so to tell doctors that they're just not qualified to recommend medical marijuana for a patient that could benefit from medical marijuana, I think is ludicrous. And it's not common sense. And so I think that doctors should be able to prescribe this and should be able to add to the registry for medical marijuana patients. And when they fill out those forms and they fill out that documentation so the patient can get a medical marijuana card, they list why they think it's going to be beneficial on that form. And so I think that that's sufficient for the process and that it doesn't need to be overly micromanaged by DPS or the Attorney General or the Department of Health.
Thank you. Just for your information and maybe to correct a misconception in the public, if a doctor is going to prescribe a controlled substance like oxycodone or others, you have to be able to be on the electronic registry and it's monitored, and so it's not exactly like they can just issue scripts, because we've had a lot of abuse of controlled substance drugs, and so public safety does manage that. So it's not quite as open air as you had suggested, just for the record. Anybody else wishing to offer comment on this measure? If not, members, any questions? Senator Ruderman.
I don't see a Department of Health testimony, but I believe you spoke in opposition to it. Is that right? Did you submit testimony that I simply don't have? Could I ask you a couple of questions, please?
You want to identify yourself, too, for the audience?
My name is Scottina Ruiz. I'm with the Department of Health Medical Marijuana Registry Program.
Thank you. I'm asking you these questions that have been raised by various testifiers because you're the Department of Health, not because I think that's what you said. A lot of the concerns seem to be about the ability to identify 5% concentrations or less or more. If that were to go away, would that make this more enforceable or less problematic? If we didn't specify the THC percentage quantity that
So you're saying that if we just let physicians certify any patient, regardless of condition and regardless of THC content, would that be easier for us to regulate
I'm
from
only
our
talking
side?
about the THC content at this point.
Okay, but adding some type of, because this adds a condition or the ability for the physician to certify,
The
correct?
ability for a physician
Okay,
to...
so if you would open it up, you're correct, because I wouldn't have to differentiate. Right now, my system, or the system that we're using for the registry as well as for the dispensary, does not have the ability to differentiate one patient from another based on a THC content. So just specific to your question, Yes, but we would still probably be in opposition to it.
I understand, and I assume that would
Yes.
solve some of the problems for law enforcement, and they're concerned that they would not be able to tell the difference between those two categories of THC. So when there's qualifying conditions established for a medicine, do those sometimes change over time?
These conditions?
No, in general, let's talk about not controlled substances like oxycodone, but the general formulary of medicines available to the physician. The qualifying conditions for those medicines tend to change over time, don't they? As new treatments or new benefits of a medicine might become known. It's not static, right? It changes.
I would imagine. From my position, I probably am not the best to answer that question for a general health perspective. With regard to this law and this program, then I could give you that answer. But
So does a doctor have fairly broad discretion in prescribing a medicine for various conditions? Once again, putting aside narcotics and controlled substances, do they have fairly broad discretion in which medicines to prescribe?
as far as I know, yes.
There's been some reference to debilitating conditions being the only ones that ought to have this prescription. Where does that come from? We prescribe medicines for non-debilitating conditions all the time, don't we?
I would imagine, but the law as it stands is based on these conditions as outlined originally in the law, and then with the addition of PTSD. The petition process, as was referenced earlier, was never introduced until this past year, and it's still to be implemented. But yeah, so it's really based on how the law is written, which is outside of...
So it currently says only debilitating
Correct.
conditions, and then we've added one more.
Correct.
Okay, thank you. So medical marijuana is, in terms of the research on it, is obviously quite new compared to the overall history of our pharmacopoeia. And it's obvious, would you say that it's evolving? Isn't it rather probably
It's
evolving?
non-existent. The research?
Yeah.
Yeah, it's evolving, but it's because there's a contradiction between federal law and where we are as a state, and with nationwide this trend for looking at medical marijuana or marijuana, the plant, as a medicine. So there is very limited research out there right now, and the fact that we've moved forward based on certain conditions and anecdotally have seen benefit, I think, for certain patients with certain conditions in certain age groups. Yeah, but it is evolving, if that's the question.
That is the question. So with most medicines, we grant physicians quite a bit of leeway to prescribe based on what they perceive and what they've read in recent research, and it's not necessarily what's written in stone, but they have fairly broad discretion in prescribing medicines, right?
Correct, but they do not prescribe medical marijuana. This is a registration program. So all they do is they certify that the individual before them meets the conditions set forth in the law, naming those debilitating conditions.
I see.
And so that is the limitation here. This is not a script program. It is not a physician discretion program. It's a registration program, and that allows us then to balance the needs of the patient with law enforcement's ability to ensure compliance and keep us as a state out of the federal radar, because it is still a controversial Schedule I drug.
Thank you very much. That's all my questions. Thank you, Chair.
Thank you. Any other questions?
Chair,
Yes.
Attorney General. You brought up the Cole memo. I didn't bring my copy of it, but
I brought mine.
from my recollection, and I want to compare the Cole memo too with the Rohrabacher-Farr amendment, which is the more recent amendment that Congress passed, basically stating that if patients and dispensaries and doctors are in compliance with state laws, more or less the DOJ and the DEA, will not go after these individuals or stakeholders. Is that
That's certainly
more or less?
close. The Rohrabacher-Farr Amendment, which really extended the original Hinchy-Rohrabacher Amendment, basically says that the DOJ is not awarded funds and not supposed to use its funds to prosecute people who are following state laws that have been enacted in the states, and it names the states, and Hawaii is
Right.
included in the specifically named state. But that doesn't mean that it's legal.
I didn't say that.
Yeah, well, but I mean, I want to make sure that we know that distinction, because the Rohrabacher-Farr Amendment isn't saying states, this is legal, you can do what you want with it.
Right, but it certainly clearly makes it clear that state law can be legitimate and can be passed for medical marijuana for patients, right?
That's certainly the implication, sure.
The trend is going in that direction, it looks like, from the 30s when marijuana was completely banned to now we have medical marijuana, now we have legal. So the discussion is moving forward. So my point is, since this is about state law, and I don't think we're doing anything that's really major harmful for the patients or the doctors. I mean, although some people are testifying that this is going to make things worse, which we agree to disagree, and I think that's the way life is in general. So, I mean, if we were to pass this, we would not really be in conflict with the federal lean or the federal opinion on medical marijuana.
Well, I really can't agree with that, because the federal schedule still has marijuana scheduled as a dangerous drug, a Schedule I dangerous drug. So I understand what that amendment says, and it seems that to say that they may not prosecute. However, it doesn't say they won't. And going back to the Cole memo, and if you want to see a copy, I would share mine with you.
But with that aside, I mean, seriously, do you really think the DOJ is going to come after somebody, a low-level THC patient?
I don't know, but they
doctor?
could. I don't know. They could. The answer is that they could. And as the law enforcement agency that I work for, we can't advocate doing something illegal.
But they could also shut down our complete dispensary system if they wanted to, right? They could do that
I
tomorrow.
believe they could.
They could shut down the DOH and have these people out of a job tomorrow, right? They could, right?
If they think that the state is violating their law enforcement priorities, I believe they could still.
And do you think they're going to do that? What's the likelihood that they're going to do that?
Oh, gosh, I sure don't know.
Yeah.
I sure don't
I'd
know.
say
I
it's-
haven't seen
I'd
it
say
done in
it's
other
this
states.
This much. That's what I'd say. Okay. And even if we were to allow a doctor to help a patient with medical marijuana, I think it would be that much too that they'd come after us. I mean, I think this is really an internal debate that the feds want to stay out of. And I just don't understand how, we've got such other dangerous drugs out there and prescription drugs and pills and things that people get addicted to. And now we're just looking at maybe a low-level medicine that suddenly everybody's up in arms about. I'm just flabbergasted.
Well, I think an analogy that might, and I'm not going to make your case for you because I have to, continue representing the law enforcement side, but I think you could look at those states that have decriminalized
Wait, let me ask you,
marijuana.
what do you mean you're representing the law enforcement side? What does that mean?
Well, I mean, I need to...
You work for
I
the
need
state of
to-
Hawaii, right?
Well, there's an ethical consideration that just came down within the last few months, saying that any attorney that represents somebody who's doing something with marijuana has to make sure they point out the illegalities. So I make sure that I am following...
She's covering her ethics.
my ethical code, and I am going to point out that this is a federal Schedule I controlled substance, and somebody in the feds or Congress says this is dangerous. It's them. I'm quoting them.
I understand.
But I think the point that you're
So don't
making,
hassle.
if you're going to have a doctor give this to everybody and say, well, that's between the doctor and the patient, which usually things are between the doctor and the patient. But if you're going to do that, why aren't you just talking about decriminalization? Because
We have.
Rohrabacher-Farr, well,
We have.
I mean, and certainly not in this bill, but Rohrabacher-Farr, maybe your assessment that that's going to make this amount of enforcement, maybe they're going to do that amount of enforcement, if you decriminalize it. But I think what this committee has in front of it is a bill that is still treating this as a medical issue. And if you're going to have doctors telling patients that this dangerous Schedule I controlled substance is something that is going to help your health condition, I think we need to distinguish between true medicine and fun.
Right.
And that's whether the feds are going to go down on that or not, I really can't predict.
Well, I think your comment, though, when you say this dangerous Schedule I medicine.
I'm quoting Congress.
I understood, but I mean, I think you and I know this is not a dangerous Schedule I, because Schedule I implies no medicinal use. So the fact that all these states have passed it just shows that Congress doesn't got their together to change it, because they don't have the to do it. So
We've known that for a long time.
at this stage, I think I better end my discussion.
You're treading. Thank you. You're welcome.
Thank you.
Anybody else? Okay, let's go to the last bill on our agenda. The next item on our agenda is Senate Bill 2523, relating to medical marijuana. Chair recommends that we pass this with amendments to make it applicable to Phase 2 so as to not interrupt current license award process. To note that the contents of a greenhouse shall not be visible from the thoroughfare, not visible to passersby. We'll find out whatever the appropriate language is, because that's the visibility. To make sure that it's secure. Just because it's a greenhouse doesn't mean that it can't be secure or can't be made to be invisible to passersby who, quite frankly, everybody's going to know where these things are growing, so you just want to keep people out. But we've seen production facilities on the mainland that, quite frankly, are greenhouses. They're not the flimsy see-through glass or shade contraptions that I think people normally think of greenhouses. But I think that there should be an ability to access sunlight. You can do it with opaque glass. It doesn't have to be see-through. So we're going to try to fashion something that goes along with what's already in the statute. And we're also going to put into the committee report that probably, to some extent, even though the department's administrative rules say no greenhouses, they didn't define it either. But you could construct, in the committee's view, a greenhouse that comports to the security and other features. The one thing I think we're going to eliminate is the open-air growing operations, and let me explain why. One, this is medicine, and you really don't want to have a lot of pests and other stuff inside. You don't even want to have to use any kind of pesticides, whether they're organic or otherwise. But the bigger problem the chair views is that we're pushing to grow hemp, for industrial hemp, for a variety of applications. And hemp has a lot of pollen. It grows up straight like corn. Medical marijuana grows kind of bushy. But if you have hemp in an area, even if it's ostensibly miles away from where you're growing outdoor marijuana, you're going to neuter all those marijuana plants. And that's, one of the considerations. Now, I know that some of the folks that are looking to grow hemp on a large-scale basis, they're trying to do it the right way. They're going and getting their DEA permit. But we're going to see some of that. So you don't want to compromise the two, because the pollen from hemp will destroy anybody that's doing medical marijuana outside, or any other kind of marijuana outside for that matter. So the recommendations would be to pass with amendments, the ones I've outlined, effective date for 7/1/2050, so we can continue discussion. Any comments from members?
Comment.
Sir.
First of all, thank you, Madam Chairman, for your expert knowledge on marijuana enhancements.
I learned
I hadn't
a lot.
thought about the outdoor pollen problem. Given this legislature's proclivity to be so interested in drugs rather than in diversifying our economy or lowering the cost of living for people here, I think this could be a great job creator also with your suggestions for contractors, how to build greenhouses and all that. And I think we should take it one step further and amend the bill to include affordable housing. I think that would really be nice and be a perfect match. So other than that, let's do it, Madam Chair.
Okay, thank you, Senator. Just to note, I have it, but maybe I didn't articulate it, that we will make sure that when we're talking about visible, it's visible. It's the contents visible from the outside. I don't know that we can figure out how not to make the production facility invisible, because everybody's going to know where they are anyway. All right, recommendation of the chair is to pass Senate Bill 2523 with amendments. Any other comments? If not, chair votes aye.
With 6 members. I know in Maui you have a place called Happy Valley that might get a different note.
Yes, it might be a little rainy for that, but oh well. Okay.
With 6 members present, are there any reservations? Are there any objections? Hearing none, measures adopted.
Okay, let's go on to the next one. Another medical marijuana bill. This one is Senate Bill 3009 to amend the definition of debilitating medical condition, and it had the 5% THC in it. Chair believes, have had some discussion with the committee members. I think we all agree that this bill needs a lot more work. Maybe some would say just a little more work, but I think it needs considerable work. And so Chair's going to recommend to the committee that we defer this one indefinitely. The last item on the agenda is Senate Bill 2389. This would relate to the development of our AP All Payer Claims database. This is certainly something that the chair supports and would like to visit with some of the key stakeholders for some amendments. So rather than making the amendments that I had outlined at this particular time, I'm going to defer decision-making on this until the 24th at 10:30 in conference room 229, and by then hopefully we'll have a draft that will be more inclusive of some of the concerns that have been raised and can move it forward to the floor of the Senate at that time. And I believe that brings us to the end of our agenda. And members, we do have a hearing tomorrow. At what time? 9 o'clock? Okay, we'll see everybody tomorrow. Thank you. We're adjourned.